It's my great pleasure to welcome you all to the 7th edition of the Helsinki International Arbitration Day. This is the 4th time I have the privilege, as the Secretary General of the Arbitration Institute, to welcome you to the conference. This year, I'm delighted to welcome to the stage with me Petra Kiurunen, the new chair of the FAI board.
Thank you.
Petra, nice to have you here.
Nice to be here.
A good thing of being involved in the arrangements of a conference is that you may actually influence the conference topics. And being a great fan of sports, I managed to get sports arbitration as one of the topics, and I'm eagerly waiting for the interview between Professor Richard McLaren and Markus Mannenin. It's an honor to have you both on board. To be honest, there was a bit more profound thinking behind the choice of the conference topic than my or Petra's or the organizing committee's personal wish lists. I think, Petra, you put it nicely in your closing remarks for last year. You said that a theme for a conference should be, if not hot, at least warm in the sense that the topic is fresh enough to prompt discussion and interest, but also to give some new perspectives. Petra, would you like to elaborate on the topics of this year's conference?
Thank you, Heidi. And a warm welcome from my side as well. What do you do when you are looking for ideas for conference topics? Well, at least I Google. So this is what we did. We Googled. And if you type hot topics in international arbitration, what do you get? I have a couple of examples. There's quite a lot of hits for those search words. This is the first example. With the development of software and technology, online arbitration may significantly accelerate proceedings and reduce costs. Now, this is a quote from an article in the Northwestern Journal of International Law and Business from the spring of 2002, which means that technology was a hot topic in international arbitration at least 16 years ago. Okay, another hit. Again, a quote. One of the issues identified as a hurdle to growth of international arbitration was transparency. And the same source identified advancement in technology as one of the current hot topics. Now, this was the IBA ARB 40 subcommittee report, Current State and Future of International Arbitration, and this was slightly fresher, 2012. Well, after 4 or 5 of similar hits, ranging from 1991 to somewhere around 2015, I added 2018. So hot topics in international arbitration, 2018. Then I came across with the recently published 2018 International Arbitration Survey, which was titled The Evolution of International Arbitration. This is the White & Case and Queen Mary University survey. And we have here in our panelists, fresh-hand information about the report. So this survey, now a fresh one, identified some of the key innovations and factors that may impact the future of international arbitration. The following. 87% of the respondents named confidentiality, I think that's the other side of transparency, as important, one of the key issues. More than half of the respondents think that increased efficiency, including through technology, is a factor that is most likely to have a significant impact in the future of international arbitration. So, is there anything new under the sun? We thought that there's at least one thing that's sort of evident, regardless of which of these hot topics you choose, is the fact that even if we would think that international arbitration is perfect as it is now, it cannot survive in a bubble. So influences come from across the culture, across the countries, from various different sources. And this same trend you can see not only, of course, in international arbitration, but all aspects of life. So we thought that this gets us back to today's topics, is that even if we pick perhaps issues that we've discussed before, there's perhaps a new angle. So we're going to hear about technology and we're going to hear about transparency. Technology comes in the panel on how to embrace disruption in international arbitration. Transparency most likely is going to be discussed on this public-private arbitration panel. We believe that both panels try to bring something new to the table. So we're trying to look at proceedings that don't necessarily follow your conventional commercial arbitration and try to see if there's something that could be learned from these proceedings. And this, of course, is important so that we can ensure that also in the future, international arbitration is attractive, especially those who are the most important, so the clients, the users. And the third topic that Heidi already mentioned, sports arbitration, is sort of yet another angle, a different angle on arbitration that's done slightly differently than your typical commercial arbitration. And then finally, we will hear the user's perspective, which is the most important, as I said. Hopefully we'll hear what is needed, what could or should be thrown out of the current practice. And then maybe also who are the key players in driving this evolution. Heidi.
Thank you. The results of the Queen Mary and Whitehead case survey actually indicate that a significant majority of the respondents consider the arbitral institutions to be best placed to influence the evolution of international arbitration. However, as Petra said, the users are the most important audience, and therefore we should listen to the users and actually let them take the driver's seat in international arbitration. Therefore, we invited Michael McElrath, the Global Chief Legal Litigation Counsel from GE Oil and Gas, to share his views on international arbitration. As many of us know, Mike is one of the few in-house counsel who are truly active in the arbitration community. He shares his valuable views and has written several articles on the topics also to be discussed here today. Great to have you on board. But I have to stress that by users, I do not mean only in-house counsel of big corporations who are familiar with arbitration process. By users, I also mean business people, and especially those business people who are actually working in new and growing business sectors. Let me elaborate this with one example. Finland has a reputation for a hub for high-tech startups, and we host the world's leading startup event, Slush, that gathers over 2,600 startup companies, 1,600 investors, and 600 journalists from over 130 countries to Finland every November. So then we don't have a great weather, we have only Finland in November. Still. Having visited Slush myself, I dare to allege that the entrepreneurs at Slush, most of them, have never experienced an arbitration proceeding, and even the idea of spending from 1 to 3 years in a dispute resolution process is a no-go for these companies. In the Slush website, it is stated that nothing normal ever changed a damn thing. These 20,000 tech heads will. I tend to agree, and therefore I think that we should listen to these tech heads among other potential users. These users are most likely not that interested in whether the names of arbitrators are published or the reasoning for their decisions for that matter. We need to ask them, how do they really want their disputes to be resolved in the future? I think, personally, that their answers will most likely oblige us in the arbitration community to change our mindset and really think and take concrete measures on how we should shape the future of international arbitration and also dispute resolution on a general level. Actually, the Queen Mary survey supports this proposition. According to the results, even though arbitration continues to be the go-to dispute resolution mechanism, it says that actually parties are increasingly resorting to various forms of ADR in the hope that they could find a swifter and more cost-efficient mechanism for dispute resolution. And if we think that the respondents who answered this survey already note this in their answers, so I think that the tech heads, who most likely have never heard about this survey, or for arbitration for that matter, they will most likely want to have something totally different from dispute resolution.
So to sum up, we think that today's topics could be perhaps described with an old French quote. I first thought of saying that in French, but changed my mind, so an English translation. The more things change, the more they stay the same. Or do they? And this is the question that we're asking today. And let's see what our speakers think of that. So I will now give floor to Catherine Rogers, our keynote speaker. Catherine is a professor of law at Penn State and also a professor of ethics, regulation, and rule of law at the Queen Mary University. So, floor is yours, Catherine.